The University of Glasgow's IP and Commercialisation Team supports researchers, providing guidance and advice on intellectual property and commercialisation. The team is a part of the university's Innovation, Enterprise and Economic Development Directorate. The team works with researchers to identify, evaluate, protect and develop new innovations and to transfer them outside of the university through licensing to innovative companies or setting up spin-outs. The overall aim is to generate positive societal and economic impact from the university's research. Intellectual property, or IP for short, is a creation of the mind. For example, an invention, a story, an artistic work, or a symbol. Patents, trademarks, designs and copyright are all types of intellectual property protection. You get some types of protection automatically, others you have to apply for. Patents protect inventions that solve a technical problem. A formal application is required, assessed by patent examiners, and once granted, can stop others from using the invention for around 20 years. Trademarks protect a sign or symbol that distinguishes the goods or services of one company from those of others. They protect the reputation and brand of your products or services. These can be registered and last indefinitely so long as they are renewed. Design rights protect the aesthetic qualities of an item when they're determined new and of distinct character. Registered design rights last for 25 years so long as renewal fees are paid. Copyright provides protection for artistic and literary works. This includes software code as well as written texts, illustrations, films and audio recordings. In the UK, copyright is granted automatically and lasts for 70 years beyond the originator's death. Other forms of IP include know-how and trade secrets that are valuable so long as they remain confidential. The University of Glasgow owns the IP of its employees, but it shares revenues with those who generated it. IP rights can provide monopoly rights. They can also be licensed or sold. The development of new technologies is costly, and strong IP will incentivise the investment required to develop such products. When IP rights expire, products are often made available by multiple companies for a much lower price. So, while patent protection temporarily prevents others exploiting your invention, in return, others can access the information they need to copy and sell it once the patent has expired. Furthermore, from the university's perspective, grant funders often want to understand who will invest in and commercialise an innovation following the completion of the funded project. Defining what IP protection exists or is possible is a critical factor in explaining this. To patent protect an invention, certain criteria need to be fulfilled. First, your invention needs to be novel, meaning not already publicly described to others. In the rush to publish and present new findings, researchers frequently hinder their chances of protecting their inventions. If you're considering disclosing potentially valuable findings outside of the university, for example at a research conference, come and chat with the IP and Commercialisation team first. Second, your invention must be inventive. This means that it can't be obvious to a person with average skill in that subject. To give an example, if you combine two known pharmaceutical compounds for the first time and the compounds work as anticipated, there is no inventive step. However, if together they achieve an effect that is surprisingly better than anticipated, then your product may be sufficiently inventive. Third, your invention needs to have an industrial application. There are also a number of exclusions from patentability that vary between countries. Finally, the invention must be described in sufficient detail to enable others to replicate the invention. Patent applications are published around 18 months after filing, so they are a good way of finding out what innovative products are in the pipeline and what competing companies are up to. Filing a patent is a skilled piece of work that should be carried out by a trained patent attorney. The university pays patent attorneys to draft these applications. It can take several years to prosecute a patent application until it is granted or rejected. The IP and Commercialisation team helps assess the patentability of your innovation and determine who invented it and who owns the IP. Not infrequently, inventions are developed and owned by more than one party. All inventors and IP owners must be listed on the patent application, or this can invalidate it. They also explore the commercial potential of your innovation and consider what problem your innovation solves and what products could be developed, the market size and competing technologies, the current stage of development, and what further work is required to ready this technology for licensing or setting up a spin-out company. And they can help look into whether your technology is infringing any patents held by others. The university cannot support all innovations due to the time and costs involved. Deciding whether to support onward development of an innovation and whether to file a patent is really only the beginning of the innovation journey. To find out more, visit the IP and Commercialisation Team guide. And remember, they are always keen to talk to you about innovations emerging from your research, even if they're at a very early stage, so please get in touch with them.